I'm Matt Wilhelmy, and I'm the owner of Strategic Voyages Business Consultants. I'm also the author of Taboo Business Questions, What's Haunting Every Entrepreneur's Growth. And today I'm joined by Nicole Moss. She's general counsel for several different companies, mainly focused in the venture capital and mergers and acquisitions space. Nicole, thanks so much for joining me.
Thank you for having me. Glad to be here.
Yeah, in our first episode, we got to hear a little bit about your background, which is really exciting. It sounds like you've had tons of experience working with founders and companies that are interested in raising funds in a number of different ways. And so we unpacked a little bit of a case study in our first episode. But in this episode number 2, I'm really looking forward to hearing about some of these cautionary tales. You did a great job of kind of summarizing those for me. And I would love to just get, kind of the bigger story here. I've been on the edge of my seat. The first story is about a company that you mentioned had promised to pay equity to a star new employee. So I want to hear about that. And then the second story you mentioned was about a company who had raised a pre-seed, but did so on their own and maybe got into some hot water. And so let's start with the first one. This company who promised equity to a star employee. Set the scene for everybody. What happened? How did you get involved? And how did it go?
Certainly, I'm happy to. So this is a good cautionary tale because it addresses an issue that I find happens all the time with early stage companies. You get early stage companies. So this one happened to be a SaaS product, and I'm dealing with a co-founder and an executive team in place. We find a wonderful potential employee. We're so excited about him. We want him to join immediately. We don't have enough money to throw at him, but we know money is coming. And I'm going to stop using we here because now I'm counseling against doing some of these things. But the lawyer is just I might be a strategist. I'm a consultant, and obviously I have a legal bent. But CEOs are going to do what CEOs are going to do. So we go off, and the company goes off and hires the star employee with expectations of sales. And that's also a key when it comes to early stage companies. You've got to have tech and you've got to have sales. And sales is one of the hardest to recruit for. So we get this guy in, he's got this fantastic track record of sales, and he's he's just knocked it out of the park for previous companies. He's incredibly charming and affable. And the thing with sales is that you can sell one thing. Just because you can sell one thing incredibly well doesn't mean you can sell everything incredibly well. So a little bit of foreshadowing there. The issue that startups run into is they want to they want to entice people, and they really are so optimistic. So they say, I'm going to give you all of this stock, and they don't want to make it subject to vesting, and they're even less excited about structured vesting. So vesting means I'm going to offer you 2% of my company, 5% of my company. That's a really big chunk of this company. And vesting means you don't get it all today. So I'm going to give it to you over time. And that could be on a monthly basis, on a quarterly basis, on a yearly basis. What I recommend, and what is really standard in the industry, is 4 years with a 1-year cliff. And what a 1-year cliff means is for a whole year, you don't get anything vested. You could leave the company at any point and you would walk away with nothing. The reason that's important is because there's a high amount of turnover, especially in that first year. Startups aren't for everybody, and not every startup is for every startup employee. So not heeding this advice at all, we ended up offering him 2% of the company upfront, not subject to vesting. We also offered him, even though we didn't have a lot of money in the bank, we had our eye on a deal that was coming up. And we thought that we'd have cash very, very soon. We had an eye on a prospective investor who was going to come in and write a very enormous check. So we guaranteed some salary. Also a tough thing to do. It's one thing to say, here's your salary, so and just in the normal course, but we guaranteed it to sign the deal. And those ended up not working out very well.
Nicole, I'd love to hear the clarification between guaranteeing a salary and offering a salary. What's the difference?
Certainly. Well, what you can, it's really, there's not a lot of legal nuance to it. You just write in the offer letter that we're guaranteeing a certain amount per month over a course of months. And it's so that the person coming into the startup feels more comfortable accepting that offer, understanding that going into a startup is a risky endeavor. It's not just risky for investors, it's risky for employees. So we wrote in there that the in his offer letter that the funds were guaranteed for the first 6 months. And what ended up happening is that he wasn't able to make the sales. He didn't make any sales. Honestly, I was surprised at the lack of effort as well. He didn't put a lot of effort into it. And so what happened was that probably too long, but 4 months in, we just realized this is not going anywhere. We need to part ways. And what happened was that he was able to walk with a salary guarantee. So he got all of his guaranteed salary, even though we would say that you're not entitled to all of it. You're entitled to maybe 4 months of it. We don't really want to pay you anything. We didn't get the investment. We didn't get the deal, so we didn't have the money. So then we had to go find money. But he went from being an employee who, if you just have a regular salary, it's not guaranteed. You terminate, you stop working, you stop getting paid. And instead, we had to continue to pay him and pay him all of his back pay that, certainly the back pay I'd say he was entitled to. But he also didn't have any vesting provisions. So he walked with 2% of our company. And now this is a person who's not done anything for the company. He's not doing anything for the company. He's off earning another salary, and yet he's got 2% and he's got a claim on our funds that cannot be used for other things. We can't use that 2% to entice other people to come work for us. And it was really illustrative of how you should structure compensation for startup employees.
Yeah, I didn't want to assume, and I'm hoping you can clarify here, but this does not sound like an agreement that would have ran by your desk. This doesn't sound like something you would have green lighted and said, that sounds like a fantastic idea. Give away the 2%. Why don't you make it 3%? Like, this guy's an award-winning salesperson. Like, it doesn't sound like the conservative advice I bet you're used to giving, right?
You're right. In short, you're absolutely right. I didn't agree, and it's not a good idea. You can advise early stage founders as much as you want. You can tell them, although you could even say, hey, don't do this, you're going to break the law. Don't do this, it's a bad idea. Whatever it is, it's just advice. At the end of the day, that's all lawyers do. We give advice, and at some point, you realize that if somebody's not taking your advice, you maybe shouldn't be there anymore. And if it's if you're infringing on the bounds of legality, you really don't belong there anymore, because for them it might be a slap on the wrist or a penalty. For a lawyer, it could be career ending. We don't want to lose our license over a bad decision, especially when we advised against. So I mean, that's a little dramatic, but it is possible, and it is something that I've had to consider in startups before, and even part ways with companies where I didn't think that they were doing the right thing, or I didn't think that they were abiding by the securities regulations, and leave it to them to take that on and say, hey, you can interpret it that way. No, that is not my interpretation. I'll put that in writing, but we should part ways at this point. At any rate, I didn't weigh in on that. I mean, I did weigh in. I said, don't do it. And the founder who made the offer thought that it was necessary to secure a brilliant hire, and it didn't work out.
Well, I can understand, the cautionary tale there, and your literal words of caution that I'm sure you put in writing to just kind of highlight the importance of, your conservative approach. Unfortunately, those darn founders, sometimes they're off a little bit on their risk tolerance factor. They just don't quite see it the same way. And so they don't necessarily take advice. So anyway, I appreciate you sharing that story. I hope that that's a sobering one for that company, moving forward. They're not going to jump in any more of those types of arrangements. And I think a bigger, maybe broader application there is to really kind of consider the worst case scenario a little bit more soberingly. I think that that's a great job of an attorney who can appropriately. And I'm not saying over the top, and I'm not saying to, extrapolate further than it needs to be, but just to quite frankly say, hey, I've seen these things before, right? This could not work out how well you want it to. And here's the bad things that could happen, just so we're on the same page, and kind of allowing them to choose their own adventure, so to speak. But you got to at least do your job, and giving them the parameters and the outcomes is always important. And that's a really great transition into the next story I wanted to tell here, because I know of a client or an organization, I should say, that was really at the very early stages of figuring out what it means to be a business. And they didn't have any revenue. They didn't have any marketing. It was one guy who had invented this idea that he didn't even have a patent on yet. And so it was actually a piece of equipment that he manufactured and got a prototype made, but that's about as far as he went. And so he invested about $50,000 of his own money. The point of this story is that he found a business consultant who agreed to help this person monetize his invention, basically. But instead of getting paid for it, said, hey, I will, send you invoices, but like over time, I'm going to need to get paid, but you can just pay me in equity. And I don't think it was agreed upon much more than that. I can already see your eyes like kind of lighting up. That does not sound like the type of agreement you would have agreed to if you were representing the founder. But I think it goes to highlight, even without telling you the rest of the story, just how serious some of these arrangements can be. And if you leave it open to interpretation, I've had a few attorneys kind of tell me this story, and maybe you can agree. The only people that win in those scenarios are the billable hour attorneys, because they're the ones that are going to have to come in and fix it, right? They're going to have to listen to both sides, and sometimes there's arbitration, sometimes there's evidence, sometimes it's really just kind of cut and dry, but there wasn't that much money to begin with, right? And so, you're kind of getting yourself in hot water when you're a founder and you've got these really great ideas without a patent, without revenue, but now you've got this agreement with somebody who's threatening to take over your business. A few $100, maybe a few $1,000s to get some legal advice probably would have gone a long way. Have you ever seen something like that where people just really should have had, maybe a even just an introductory call with an attorney would have probably solved this one? Has this happened in your world? Have you seen this before?
Yes, certainly. And it happens all the time. And, you say the billable hour people win, but if there's no money to pay the billable hour people, either the billable hour people don't get paid or they don't come on board in the first place. And neither one of them is really all that helpful. So as a startup lawyer, there is a little element of risk that I take on as well, which is that I'm not going to get paid. And it's the same risk that they're in. So I like to think that it aligns us. The other thing we have to think about as startup lawyers is that if we're going to just be solid, conservative, this is how it has to be done, thinking inside the box at all times, we're not really going to help our clients. And we're also maybe misaligned in terms of ethos, because we want to be, I don't want to tell my clients how not to do things or how they can't do what they want to do. I want to hear what they want to do. And then it may not take the form that they thought. That's okay. They're not lawyers. They're experts at other things. It's going to be how to get from A to B in a way that is going to be legal and well documented and is going to serve their purposes, not the myriad ways that they can't make it happen. So have I seen that? Yes, plenty. They come to me all the time. How about this? And whether it's an idea on comp or something else. Let's get back to your comp example though. This fellow says pay me in equity. That's problematic. So when you get compensated as personnel, as a contractor, or as an employee, it's not just that you're getting cash in exchange for something of value, which is essentially the sale of a security. So the securities regulations apply. It's that you're getting paid to do work, which also implicates IRS regulations. And so you need to be cognizant of both of those. It is possible to be paid in equity. Most compliantly, though, that's going to be under an incentive plan that is compliant with both the securities and the tax regulations.
Yeah, I wish that this inventor would have reached out to you before he arranged to work with this business consultant. Things would have probably gone a little bit different for him. And I think that goes back to your first piece of advice, which was you just wish that people would call their attorney sooner rather than later. But I also think it's interesting to hear, Nicole, that you are more interested in not having humongous amounts of red tape. You're more interested in helping founders accomplish their business goals and strategies and dreams. But that gap between where they're at and where they want to go looks like a lot of different roads, right? You kind of help them navigate that with some legal agreements or with some guidance along the way to kind of protect themselves from things that they don't even know and necessarily they need protection from. And so that sounds like the kind of legal partner that I think a lot of firms that you work with probably come to appreciate when they're getting your advice. And so all that to say that your last cautionary tale here was about this company that decided to not get general counsel again and go out and raise some money. And so I'm curious to hear kind of how that went. What did you tell them? How did it work? What happened there?
Sure. Well, so it wasn't that they didn't talk to me. It was that they didn't talk to anybody. I joined the company after they had their initial raise. And so having joined the company, or I guess sort of in the initial getting to know you phase, I said, well, you have money. You say in your disclosures you've raised money before. How much did you raise? Where did it come from? And what were the terms? And I think that at that point, maybe the co-founder was a little bit cognizant that it didn't go down exactly how a lawyer would have advised. So after some conversations and after some digging, come to find out, they sort of let their investors choose their own adventure. So what we had was they sold some shares at one price. They sold some other shares. They sold some common shares. They sold some preferred shares. They undertook a debt with a personal guarantee, which I would definitely advise against. And then they had a convertible note. And then they doubled down. Like some of those, there were several of each. And what we had to do was unpack all of that and say, okay, so we had multiple offerings and we need to figure out exactly what you owe all of these people and are they willing to consider changing it up so that we can maybe streamline this a little bit and we don't have so many random things. So the debt we converted into a convertible note. So then there was just one kind of convertible note and everybody was agreed that that was the form and everybody signed on to that. The preferred shares and the common shares, we just treated them as sold and we sort of drew a line in the sand and said, okay, this is no more funny business. This is what you have and this is the status of play. And going forward, we're going to only do one kind of offering at a time. So I'm boiling it down and synthesizing it. That was many months of back and forth and negotiations. But eventually, we got to a cap table and a corporate debt structure that looked a lot more reasonable and that would not scare investors off. They didn't need to go look at the documentation unless they asked for more detail. They didn't.
Yeah, wow. So you were able to kind of peel back the onion a little bit and dive into the weeds, but then also come up with a win-win for everybody involved in that scenario. That's great. I think that just highlights, again, the value of having an entrepreneurial-minded attorney to really kind of guide some of these conversations. Say, hey, look, we can go about this the hard way if everybody's got to have their own unique little arrangement and setup, but your billable hours would be super high. And then like, are you really doing the best thing for the client? And you can kind of shift that, right? And just say, look, we can do this a different way too. What about this idea? And maybe it's not, the way it'll end up working, but it's getting those wheels turning of other possibilities to kind of fix the issue that they made so that then moving forward, they're not in that same spot, with 75 different agreements and people, wanting one thing. And then you have so many different payouts. I mean, just from the financial perspective, I'm thinking like my head would be spinning, trying to figure out a debt schedule and then a liability sheet and what would the balance sheet look like. I mean, oh my goodness, that sounds very complicated, but you were able to make it very simple for them. And so that's great. I wanted to remind everybody, I'm here with Nicole Moss. She is general counsel for several different organizations, but she specializes in venture capital, mergers and acquisitions, fundraising, that kind of thing, working with a lot of early stage companies in their first few seed rounds. And she's just really an overall expert in, money and when it comes to kind of startups and raising it and making sure that it's legally protected and all of that. And so really excited about our cautionary tales, but Nicole, we're going to be transitioning into solving some of the issues that we identified in our first episode here when we get started with our third episode. And so we're going to take a quick break, but before we do, just wanted to recap. We were talking about the synthetic diamond manufacturing company that had secured $100,000 to buy one machine. They wanted to get another $500,000 in an investment to buy 5 more machines, but really we kind of unpacked 3 specific issues. And so the first one was that the company didn't have a runway. They didn't really have a solid understanding of their business model. It's kind of their first issue. And then you notice that there was probably a lack of compliant paperwork and agreements, and really kind of probably no agreements in place at all, but wanted to unpack that a little bit. And then the third issue that you noticed was that they were going to have a lot of issues kind of in future raises if they weren't going to get some of these preliminary things figured out first. And so you really don't want to, get yourselves into more paperwork and more problems until you solve that first one. And so again, in our third episode, really kind of looking forward to diving into some of those solutions. Hope everybody stays tuned. Thanks.